Ladies and gentlemen, welcome to today's webinar. Today's seminar topic is Becoming a Medical Director for a Florida Medical Marijuana Treatment Center. Our presenter today is attorney Eric Boughman. If you'd like a copy of today's presentation, you can find it in the handout section of the webinar interface. And similarly, if you have a question, you can type it into the question section of the webinar interface. And now let me turn it over to Eric. Go ahead, Eric.
All right, good afternoon, everybody. Thank you for joining us today, another in our series of the first 30 minutes. These are topics of interest. Oftentimes we'll cover hot topics of current interest where we find ourselves talking to either clients or other advisors. Yesterday morning I had coffee with an accountant and some of these issues came up that we're talking about today. People are curious naturally in Florida about our medical marijuana law. There's been a couple changes over the years. There's some potential future changes coming down the pike. And so that's what we're going to talk about today. So again, thank you, Tony, for that introduction. Most of you should know my name is Eric Boughman. I'm with Forster Boughman Law Firm in Central Florida. I practice in healthcare law and represent folks in all phases of the healthcare delivery system. Today we're going to talk about becoming a medical director in Florida, so that if you have somebody ask you about it, or if you're of interest, if you're qualified, if you're a physician qualified to do so and find yourself in a position where you're asked, you'll have an idea of what the issues are you should be aware of. So here's our agenda for today. I'll give a little bit of background on how we got here with the law. And we'll talk about what the requirements are currently for a license for a medical marijuana treatment center. That term itself is of interest. I'll talk about that a little bit later in the seminar, but essentially the current law is an evolution of an old law that referred to dispensaries, but as we'll see, medical marijuana treatment centers are much broader than just marijuana dispensaries, and that's an issue that's being challenged at the Supreme Court. Because of that challenge, and the current case is pending at the Supreme Court, which is the next on our agenda here, the Department of Health v. Florida Grown. I anticipate that there could be a need, a growth of medical marijuana treatment facilities and dispensaries, and there could be an increased need for medical directors to serve those facilities, as the licensing requirements currently hold that each facility needs to have a medical director who's qualified. Again, it needs to be a qualified MD or osteopathic physician. So we'll talk about what to watch out for at the end. I've got a case study for you and a few warnings, as we always do in these seminars, things to watch out for. So we've got 30 minutes. I'm going to pop right into this. And for those who don't know, in November of 2016, Florida passed a medical marijuana amendment. We'd already had, by the way, a medical marijuana, low THC medical marijuana law in Florida prior to the passage of this amendment. So it seems a little bit redundant, but this one is a little broader, and it puts the right to prescribe, use, and obtain medical marijuana right in our Florida Constitution. That creates some interesting issues because that right now cannot be restricted by statute, and that's the issue that we have here. Is we have a right that's in our Constitution, and then we have a statute that deals with the licensing of medical marijuana treatment facilities, and that statute is bumping up against the Constitution, which is causing this issue that's now at the Supreme Court. Under the amendment, the purpose of the amendment is to ensure the availability and the safe use of medical marijuana for qualified patients. And the department that is tasked with making sure that happens is the Department of Health. And that, again, comes right from the constitutional amendment. So now we have a constitutional amendment that says we are going to have medical marijuana available in Florida. And the entity or the group or organization that's responsible for overseeing that and carrying out that law is the Department of Health. This creates a little bit of an interesting issue because generally in Florida, laws are made and start with the statutes that are created by the Florida legislature. So an initial question of interest for lawyers, and it will be of interest for anybody affected by this law as we go forward, is what happens if the Department of Health has a regulation that potentially conflicts with what the statute is as drafted by the Florida legislature, which which prevails. Typically, the legislative statutes would be supplemented by rules that affect specific departments that are tasked to carry out things like the implementation of the medical marijuana law. But here we have a situation where the Department of Health's authority doesn't derive from the statute, but directly from the Constitution, which is the supreme law of Florida and the law of the people. And so if you have a statute, again, a legislatively created law that conflicts with something that the Department of Health is doing, a rule that's promulgated by the Department of Health, then this constitutional question arises, which is supreme? And so far, it appears as though the Department of Health rules, together and supported by the Florida Constitution, would win out. And that essentially is a little bit of background there for how we're getting to this situation of where the law is being challenged and why we may see an expansion of medical marijuana licensing. And you'll have a copy of these slides. You can make notes on these slides. If you have any questions, by the way, throughout the time that we're going to be together today, if you put them into the chat box, I'll try to address them during this webinar. If I don't get to them and you want to shoot me an email afterwards, please do so, or feel free to give me a call and we can perhaps walk through it. So here you see we've got the Florida legislature passing what is now Section 381.986, which is the medical use of marijuana. And as I noted earlier, the original marijuana law in Florida, which was this low THC usage law, was a 2014 law. And the statute was very similar, but the statute was essentially updated to reflect the change that derived from the Florida constitutional amendment. Under 381.986, this statute establishes all the requirements for the licensing of medical marijuana treatment centers in Florida, and the use of the word medical marijuana treatment center appears to be essentially a substitute, because that's the term that's used in the Constitution. This appears to be a substitute for what was previously called a medical marijuana dispensary. And you would think a medical marijuana dispensary and a medical marijuana treatment center would be similar or the same, but as we'll find out, that's not the case. And as I noted here, this statute also, consistent with the constitutional amendment, delegates rulemaking authority to the Department of Health. So I'm going to sidetrack again here. I need these little thought bubbles, perhaps. In law, generally, we have constitutions and amendments. That's typically the supreme law, both at the federal level and at the state level. We have statutes that are derived from legislature. That might be U.S. Congress for federal statutes or the Florida legislature for the state statutes. And then you have rules and regulations, and these are typically something like the Department of Health or the Department of the Treasury at the federal level may have rules. The IRS may have rules and regulations. And those are typically considered a step down from legislatively created statutes. So you typically have the statute and then the rule. And here we have the rule that's promulgated by the Department of Health. That's consistent with the statute, but the Department of Health, as I noted, gets their power from the Constitution and the amendment that was passed. What's interesting is that when we talk about medical marijuana treatment centers in the statute contains specific requirements for all licensed medical marijuana treatment centers to cultivate, process, and dispense medical marijuana to qualified patients. And that's referred to generally as dealing with everything from seed to sale for marijuana. So that's the term that you will hear. Sometimes you'll hear that in news if you read anything about this, that the licensees deal with the medical marijuana in Florida from seed to sale, and that's considered vertical integration. There's another term that we'll talk about some more, but Florida has a vertical integration system for carrying out the cultivation, processing, distribution, and selling of medical marijuana, where other states most states that have a medical marijuana law or some type of marijuana law allow for horizontal distribution. The difference essentially is in vertical distribution, one entity, one licensee does everything from seed to sale. And a horizontal distribution system, which is a lot of our economy operates that way, you have different entities that can do one little piece of the distribution and sale puzzle. So let's use an analogy of Tylenol. I think Johnson & Johnson, if I'm not mistaken, makes Tylenol. Tylenol might be sold over the counter at a CVS drugstore, it might be sold at a supermarket. There may be a different distribution center that actually circulates the Tylenol out. It's not one company. Johnson & Johnson doesn't make the Tylenol, grow all the substances that go into the Tylenol, distribute the Tylenol, and then sell the Tylenol over the counter to the patient. It's all different entities that are involved in that process. But with vertical integration and with medical marijuana, we have a requirement in Florida that everything be done by one source. And so as you can imagine, there's limited licenses in Florida for medical marijuana treatment centers, and competition is fierce. There was only a very limited amount that have been allowed under the statute. And that system, the limitations imposed by vertical integration and the limitations imposed by limited licenses are being challenged in the Florida Supreme Court. The state has said that vertical integration, their position essentially, as I understand it, is that vertical integration will reduce the chances of a developing black market for marijuana. So they want to make sure that it's all controlled, and so that only a limited number of entities have control over the marijuana from seed to sale. This, of course, could be rendered moot if Florida, as expected over the coming years, expands their law not only to permit medical marijuana, but permit recreational use of marijuana, as some other states have done, and as the trend seems to be pushing. So now we have an entity that has attacked the Florida Constitution, or the Florida law, the medical marijuana law, as being unconstitutional. And this could lead to big changes. So right now, under the statute, medical marijuana treatment centers, they must possess a valid certificate of registration for cultivation and operation as a nursery. They have to show technological ability to cultivate and produce the marijuana. They have to have a proper infrastructure for the security and the distribution, and have the right personnel to operate a medical marijuana treatment center. They have to maintain accountability for all marijuana that passes through their facilities, and notably for our purposes today, that each must have a medical director to supervise the activities of the medical marijuana treatment center. Now, for anybody who's ever dealt with a Florida healthcare clinic, here in Florida we have there's essentially two regimes across the country that states employ when it comes to medical facilities. In some states, you have medical facilities can only be owned by physicians or the providers who provide the services and care that facility is licensed for. This is generally referred to as the corporate practice of medicine doctrine. And in other states, and Florida is one of them, you can have lay persons who are not physicians or have any healthcare qualifications own a clinic or a facility, so long as you have a medical director and you have a contract with a medical director who oversees the general operations. So we have that requirement in Florida. We had it for dispensaries, and we now have it for medical marijuana treatment centers. But this might get some people scratching their head thinking, why would you need a medical director to grow marijuana? What does being a qualified physician have to do with having a marijuana farm? You can count me in among that group. I'm not quite sure why you would need to have a medical director for essentially what is a nursery or a growing farm to produce marijuana in its raw form, but currently that's what the statute appears to require, and that's what's being challenged. Pardon me here as I flip to the next slide. All right, so the medical directors, and this is one of the components when you apply for a medical marijuana license in Florida, you submit this long application with all this information. People undergo background checks. You have to show financial wherewithal to be able to operate the facility. and be able to sustain operations for a long period of time. The application itself in Florida costs approximately, I think it's $63,000 is the application fee. One of them sold for, gosh, I should have looked this up before today, but it was in the millions. I want to say it was $14 or $40 million, just the once somebody had an approved license and they sold it. So again, fierce competition, limited number of licenses, and tough to get one, and you have to have a medical director, and the part of the qualifications are based on the qualifications of your medical director. The medical director must be an OD or an MD. And then the application asks about these different qualifications, the specialty area and experience with various types of patients who might be served by medical marijuana treatment. Now, I'll also mention that being a medical director is different than being a qualified physician to write a prescription for medical marijuana. To be a qualified physician, you have to take a different certification course. It's a different qualification. By the way, I've been asked, and just in case anybody has this question, you cannot own a medical marijuana or have a financial interest in a medical marijuana treatment center and also be a qualified physician who writes prescriptions. So here we're going to stick with just the medical director requirements, but they still have to have a background of knowledge as shown on the slide here. And both qualified physicians and medical directors have to complete a 2-hour course that's administered by the Florida Medical Association or the Osteopathic Medical Association. And there are 2 different courses, one for medical director and there's a different one for a qualified physician. And then that course you have to be re-examined periodically for that qualification. So here's the changes that I talked about. This is the FloriGrown case. And FloriGrown was formed as a medical marijuana provider, and it applied for a license. And of course, it was turned down, and they filed suit suing the Department of Health, seeking to declare that the medical marijuana treatment facility or treatment center limitations were unconstitutional, because the statute is supposed to provide for, the argument is the statute doesn't provide these limitations and is supposed to provide for a broader distribution of licenses, broader availability, and these specifically the attack focused initially and primarily on the vertical integration of the statute, requiring a medical marijuana treatment center to do all of that long list of laundry list of things that we discussed earlier. And the FloriGrown sought a temporary injunction to declare the statute unconstitutional and cause the Department of Health to essentially approve additional licensees' applications. And in the circuit court, Florida, we have the circuit court, you have the district court of appeal, and then you have the Supreme Court as the highest court, 3 court levels. At the first court level, FloriGrown won. The case went on to an appeal at the first district court of appeal, and FloriGrown essentially won again. There were some revisions made to the original order, and now that case is up at the Florida Supreme Court. And while it's up at the Supreme Court, we've got arguments that are being scheduled now. There were some initial arguments, and you can actually pull them up on YouTube if you're interested in hearing those. Google FloriGrown and Florida Supreme Court, or go on YouTube and do that search, and you can listen to the arguments. And I'm going to try and boil those arguments down into about 3 to 5 minutes here, but you can listen to the full argument if you're interested in pulling the papers or reading the briefs or the earlier opinions. Those are all available publicly online as well. And there's some arguments that are scheduled now for October 7th, 2020, so coming up. And after those arguments, I anticipate it could be a couple of months. Clients will ask, how long till we hear something on the appeal? Could be a couple months, could be several months. There's no set time during which in a Court of Appeals, either at the mid-level Court of Appeals or the Supreme Court, will issue an opinion. But I anticipate that they probably will act on this relatively quickly because it's such a hot button issue. And so here's the issues. The first in FloriGrown is this vertical integration that I talked about. And you see this little picture on the slides here that kind of gives you an idea. It's all one entity from seed to sale that does everything associated with providing the medical marijuana from the time it's in the dirt to the time that it ends up with a patient. There's also a challenge based on the license, the cap on the number of licenses, because those licenses were limited. And Florida says that that cap is unconstitutional because it's not in the original constitutional amendment. It was added by this by the statute and then the rules implementing the statute. And Florida also makes another argument. It's a pretty interesting argument, I think. And this came up during, I really saw this come up during the course of the oral arguments, where they've argued that the law is a special law, and and special laws are unconstitutional in Florida. And what they mean by special law is that it applies only to a limited class of people. And here, Florida says that the law essentially applies, it allows licenses to be offered to two groups of applicants. The first are companies that had been licensed after the original law was passed in 2014, and then, so those applicants were essentially grandfathered into this new law. And then the second is companies who were not chosen in the earlier round of licensing, and a lot of those companies had filed lawsuits similar to the floor-grown suit against the Department of Health, and the second round of licensing and the approval of applications was limited only to those companies who had applied for licenses and had been turned down or currently were involved in some type of litigation. And there's a pretty good argument that the Department of Health, supported by the legislature, essentially used the approval of licenses now under the new constitutional amendment to settle those earlier cases. And I think that's a pretty good argument. But the constitutional argument is that this is an unconstitutional special law that basically gave privileges, the right to operate a medical marijuana treatment center, a licensed treatment center in Florida, to only these two classes of people. The Supreme Court, they clung on to that argument. What happens sometimes is an argument may not be raised properly in your appellate brief, and there may be a little technicality where the court will say, well, that argument wasn't raised earlier, so we're going to waive it, or you waived it, so we're not going to hear it. We're not going to determine the case based on that argument. But here, that argument took hold in the last round of oral arguments, and the court started asking questions about it. And what they've done is gone back and asked the parties to specifically appear at this next round of oral arguments on October 7th. And my understanding from the order is that they're specifically focused on this third issue, that the law is a special law. And the fact that they're calling the parties back to talk about that particular issue, again, it tells me that they're focused on that. And I think that there's a good chance that they probably find that this is an unconstitutional special law, as they would call it. And so what happens here is if the Florida-grown case ends up being upheld at the Florida Supreme Court, as it has at the lower courts, and Florida-grown wins, then we're going to probably see a transition from horizontal integration, from vertical integration to horizontal integration. Then we'll see a transition to, with horizontal integration, to more independent, non-integrated marijuana licensees. So these will be folks, some folks might only provide the farming and cultivation, some folks might only find the dispensaries, and some folks might be involved in the distribution, but that will be broken up because we'll have a horizontal system. We'll have more licensees, folks licensed under the marijuana law, and this will could have the effect of increasing the demand for medical directors. Now, will an operation that solely is involved in farming and cultivation be required to have a medical director? To me, that seems a little silly. Perhaps we'll see that medical directors are only required where there is some type of potential, interaction with patients, and that would be at the dispensary or something similar to that. But we could see a growth, and we could see an increase in licensees, and that could bring an increase in medical directors, which is why I wanted to do this seminar today. So with an increased need in medical directors, we look to physicians and ODs who could be qualified to be medical directors. And this is where I want to point out some of the issues to be aware of. And this, by the way, goes for anytime somebody is going to serve as a medical director. You need to understand that there's responsibilities, that this isn't just a rubber stamp operation. You put your name on the door, you're the medical director, and now the clinic can open because your name is there. You are actually agreeing to take on certain responsibilities, and you're essentially responsible for all of the day-to-day supervisory responsibilities of the specific medical clinic, or in this case, a medical marijuana treatment center for which you are a medical director. And first is you have to have a written agreement with the clinic where you agree to assume all the responsibilities for that operation. In lieu of the medical director written agreement, there is a form that's used by AHCA here in Florida, the Agency for Healthcare Administration, and that form is used for other clinics. I'm not sure if that would suffice for medical marijuana treatment centers, because as I read the law, it looks like you need a separate contract. But in any event, you're going to need some type of written document where the medical director agrees to take on these responsibilities. And those responsibilities are things like making sure that any other practitioners working for the clinic have active and valid and unencumbered licenses, ensuring compliance with record keeping and adverse incident reporting requirements, conducting systematic reviews of billings to prevent fraud. You're responsible for any unlawful billing that takes place in the clinic. If you're the medical director, it doesn't matter if you're the one actually providing the treatment. You're the person that government entities and insurance companies and individuals can look to if there's a problem with billing. You're responsible for preventing unlawful referrals, such as those that might be in violation of the Florida Patient Self-Referral Act or the ANA Kickback or Federal Stark Act. And you're also responsible for making sure that a clinic publishes a schedule of charges for services that are offered. These are just some of the responsibilities that you take on as a medical director. And in Florida, you are limited to serving for no more than 5 clinics with a cumulative total of no more than 200 employees. And those clinics all have to be within a certain geographic area, all within 200 miles. Now, with all of those responsibilities, if you're a medical director for 4 or 5 clinics, that to me seems like a full-time job. In fact, being a medical director for just a couple of clinics could seem like a full-time job. And so be careful if you have a client, or if you yourself, if you know of somebody who's considering or has been asked to be a medical director, understanding that you have these responsibilities. And I just want to point out this case as we wrap up. And we started about 2 minutes late, so I'm going to go about 2 minutes over. And again, thank you for joining us today. And I want to point out, here's an interesting case that I came across. It's not involving a medical marijuana, but it does involve medical directors. It's State Farm v. B&A Diagnostic, Inc. This is a recent case in the Southern District of Florida where medical directors were sued. And I just want to read just a couple quick portions of this case. The medical director had, in this case, there were 2 medical directors sued along with this clinic, and they were unaware of the fact that they had particular statutory obligations under Florida law, including the obligation to ensure everybody was licensed properly in the clinic. They had testified that they had no role in interviewing, hiring, or approving any of the technicians who were supposed to be licensed and work on equipment. The medical director was not aware that it would be a violation of his statutory duties to allow bills to go out containing charges for services performed in violation of Florida law. There's a litany of other allegations against the medical directors in this case. Because they failed to meet their obligations, State Farm sued and said, well, we don't have to pay you for outstanding bills, and we're entitled to recoup certain payments that we made that were billed unlawfully by the clinic, and we're going to recoup those against the clinic and against the medical director individually. So 2 individuals who'd served as medical directors during 2 different time frames were sued. And this is actually rather tame compared to some of the other ones I looked at, but ultimately State Farm got a judgment for $316,000, for $178,000, and they were also a couple other judgments against different defendants, and they were also not obligated to pay about $700,000 in outstanding bills that were due. Again, these sound like pretty big numbers. Nobody wants to be, first of all, you don't want to be sued. Second of all, you don't want to be sued and have a judgment entered against you for a 6-figure sum. But there are cases that are ongoing. In fact, our firm, we're involved in one right now. It's totally different parties. in the Southern District of Florida, but it's certainly public record, where clinics and directors and service providers are being sued, but not only by government entities, but by insurance companies. This seems to be a big thing now. And so I want to bring that to anyone's attention to let you know that if you're going to take on the responsibility of being a medical director, understanding that the industry is under a lot of change right now, and there's probably going to be some opportunity and a demand for new medical directors, but with that opportunity comes duties and responsibilities, and don't lose sight of those when you're taking a look at this. So that is our first 30-minute session, again, for September of 2020. Thank you very much for joining us. I expect these marijuana issues will be hot button issues over the next few months. We also do, by the way, I drafted a lot of agreements for medical directors for clinics in all different types of industries, not just medical marijuana. But anytime you have a healthcare clinic in Florida that's not physician-owned, you're typically going to need a medical director. I appreciate you joining us today, and want you to have a great rest of your day. Thank you. Bye-bye.